to a large extent, employers, employment lawyers, tax lawyers have got a good understanding of that now. So we're not going to look at that in too much detail. And now we're moving on to what is the third phase of coronavirus, and that is all about how are we going to get the workforce back, how are we going to return to some level of normality, and that obviously has been reflected in the guidance and the announcements that the government has made over the last couple of days. Jaspal is also going to take a quick look at the self-employed income support scheme, which is something you don't hear a lot about, but may be relevant to some of you, and certainly relevant to some of the contractors that you may engage. So first of all, we'll look briefly at the job retention scheme, which I'll refer to as furlough for most of today's talk. The current information we've got from the government as of the 3rd of May is that there have been 6.3 million claims in relation to 6.3 million jobs. So that's not necessarily individuals, as people can be furloughed from more than one job, from 800,000 employers worth a total of £8 billion. Estimates suggest there's going to be around a cost of £45 billion for 3 months, and I've heard the figure of around £12 billion a month thereafter. Scheme went live on the 20th of April in terms of the online portal went live, and as I understand it, that's working fairly well. Employers are making claims. Some employers have actually already received payments under the scheme. Now, I'm conscious not everyone will necessarily be familiar with the scheme, so the next couple of slides, which I don't propose to talk through in detail, just set out some of the basics. We do have on our coronavirus hub a question and answer document in relation to the job retention scheme. But in brief, it runs from the 1st of March and currently till the end of June. It's open to all UK employers, with some limitations on public sector employers or those who have employment costs funded via public funds. They can still apply, but there are more hurdles those employers have to overcome. It applies to not just employees, but workers, salary partners and LLPs, statutory directors and agency workers. The key data you see from the screen there is that the employee or worker, whoever it may be, must have been on PAYE payroll on the 19th of March and also have had an RTI submission in relation to a payment by that same date. Importantly, an employee needs to agree to furlough, cannot work when furloughed, and must be furloughed for a minimum of 21 days, 3 weeks. So that's a very quick overview. And the next slide just sets out that it's covering most of the employment costs, up to 80%, or the relevant monthly, daily, or weekly figures as set out in the screen there. And importantly, all of the money that is received under the furlough scheme must be passed on to the employee, subject to deductions for tax and national insurance. I'm now going to pass you to Jaspal, who's going to look at some of the claim element of the scheme and dealings with HMRC.
Thank you, Michael. Good morning, ladies and gentlemen. As Michael says, I'm going to talk briefly about how an employer makes a claim under the Coronavirus Job Retention Scheme. The scheme is actually administered through the tax system by HMRC, and HMRC have built the systems for the scheme from scratch in just a month. Early indications seem to be extremely positive. The online portal appears to have held up well from opening on the 20th of April, and we understand that employers receive their first grants within a matter of days. It is HMRC's intention that employers will be able to self-serve and use the online portal without additional assistance. In this regard, HMRC have issued the 80% guidance, the Coronavirus Job Retention Scheme calculator, and a YouTube video assisting employers in calculating their claims. HMRC have also increased the number of employees on its helpline. To claim, the employer will need to be enrolled for PAYE online and submit its claim via the government gateway. A number of pieces of information are required, including information about the employer and the employees being furloughed, the claim period, including an end date that is not more than 14 days after the date of the claim, and details of the amounts being claimed. HMRC has sped up the process for employers to register for PAYE online, and in particular, we understand that HMRC are dispensing with the usual requirement for an authentication code, potentially saving employers around 10 days. In practice, a claim under the scheme can only be made at the point in time at which the employer runs payroll or in advance of an imminent payroll, because actual payroll amounts need to be submitted. If the employer is claiming in respect of fewer than 100 employees, the employer will need to enter details of each employee manually. We anticipate that this will involve a lot of manual keying in of information. Where the employer is claiming in respect of 100 or more employees, the employer will be asked to upload a file in a supported file format containing the relevant information. Where the employer has an agent authorised to act for PAYE purposes, the agent will be able to submit the claim on the employer's behalf. However, where employers use a file-only agent who only files their RT1 returns but does not act on other matters, that agent will not be able to submit the claim on their behalf. After an employer has submitted their claim, they will receive a claim reference number. HMRC will then check that the claim is correct and pay the claim amount via BACS into the employer's bank account. The employer must keep a copy of all records for at least 5 years and tell their employees that they have made a claim under the scheme. HMRC have advised that it is aiming to pay employers 4 to 6 working days after submission of their claim, and this is consistent with what we have heard on the ground. Finally, payments under the scheme are treated as taxable income for employers on the basis that the corresponding wage costs will continue to be deductible as normal. We would accordingly expect claims on the scheme to be tax neutral. As Michael has already said, amounts paid to employees will continue to be subject to PAYE, NICs, and minimum auto-enrolment pension contributions in the usual way. And I'll hand back to Michael. I think we may be having technical difficulties here, but I think Michael is going to talk about some further points to note in relation to furloughing.
Can you, yeah, sorry everyone. They should never have left me in charge of the technology. We've got up on the slide there some points to note in relation to furlough. So these are essentially issues that employers have raised with us. So I'm just going to highlight some of them now. And I know a few questions we've already had about the first bullet point in relation to annual leave and furlough. So the key point is annual leave, and an employee who is furloughed is still an employee, and annual leave continues to accrue whilst they're on furlough. It's also possible for the employee to take annual leave whilst furloughed, and that can be by them requesting leave or even the employer requiring the employee to take leave. Now, unless there is an agreement in place that varies this under the working time regulations, if the employer wants an employee to take leave, they must give them twice the length of notice as the period of leave. So for a 5 days leave, the employer must give the employee 10 days notice. The employee, if they want to take leave under the working time regulations, should also give the same length of notice. So for 5 days leave, they must give 10 days notice. So that's possible, but for statutory leave, an employee must be paid their normal remuneration, so effectively their full pay or normal pay whilst they were working. So a point to note is that if you do allow or ask employees to take leave whilst on furlough, if you're not paying them 100% of pay as it is and you're only paying them the 80% available under the furlough scheme, then you will have to top up that pay. Now, one of the questions we've had in already, which is relevant to this section, is if an employee has 15 days holiday booked in December 2020, but has been on furlough since April, can we make them, with appropriate notice, take some holiday during furlough? So the first element with that question is, if the employee has a period of leave that you might want to cancel, you've got to give a period of notice that is equal to the length of leave. So if you wanted to cancel 15 days leave in December, you'd have to give that employee at least 15 days notice of that. Again, assuming that there's nothing agreed differently in the with the employee in the contract of employment. And then you can require an employee to take leave during furlough, but as I said, you need to give double the amount of notice as the leave to be taken. So again, for 2 days leave, 4 days notice must be given. Another question that's come in, and it's a similar point to the one I just made around holiday pay, is in relation to notice. Pay in lieu of notice cannot be recovered under the scheme. So if you pay an employee a lump sum on termination of their employment whilst furloughed, that would not be recoverable. However, if the employee effectively serves their notice, so they're given their 4 weeks notice and told that that will run during the next 4 weeks, then some of the furlough pay can be used against that notice pay. However, and it's a little complicated to go into here, but there are certain provisions around notice that effectively mean most employees, certainly those who are only on statutory notice, will usually be entitled to effectively their full pay during the notice period. That again means that if you're paying less than full pay, you're likely to have to top up their notice pay. So just something to be aware of there. Another point that has been clarified recently is around trade union duties and employee representative duties. The guidance now makes clear that those duties can be carried out during furlough and they won't amount to work. That is important because particularly for the likes of collective consultation or collective bargaining with the union, an employer will need to engage with the employee reps or the trade union reps. Another point that's come up as well is directors. Directors can be furloughed if they meet the PAYE payroll requirements, but they are limited to only carrying out their statutory duties. So a point to note there is if you expect the director to maybe get the business up and running, be business developing, then they're not going to be able to carry out those functions and be furloughed. So it could in practice be difficult for many directors to actually be furloughed. Now the future. So as things stand, we've got some questions there, but I believe later today the Chancellor is actually going to answer some of those questions. So you may have already heard in the newspapers the scheme could potentially be extended in some form till as late as September, I read this morning. There seems to be a suggestion that the scheme may continue beyond the end of June, but it could be tapered. So instead of 80%, that might be reduced, for example, for 60%. Another suggestion, which I think would be really helpful for employers, is that it might be possible for employees to work whilst on furlough. So furlough effectively acts as a top-up. And I think lots of employers, certainly ones I've spoken to, feel that that could be really beneficial because they have some work, but not necessarily enough to provide the employee with the full-time work that they have at the moment. Now, when it comes to returning from furlough, and this is an issue that is starting to be asked about because the first furlough periods are coming to an end. It must last at least 3 weeks or 21 days in order for you to claim a payment under the furlough scheme and not have to repay that payment. So an employer could always end the employee's leave early, bring them back if they need to, but they wouldn't be able to claim under the scheme for that employee or may have to repay any payments that they have received. In terms of notice, there's nothing set out in the guidance or the direction. And if you haven't agreed a notice provision for when the employee will return, then there's no strict requirement, but good practice would be to give the employee reasonable notice, because it could well be that the employee has, for example, childcare responsibilities and need to make arrangements in relation to that. If an employee refuses to return, You could consider extending that furlough if the scheme is still available and the employee has a good reason for not returning. But our advice is that if somebody is reluctant to return, and it could well be around coronavirus anxiety and a worry of catching the disease, engage with that employee, speak with them, try and identify what their concern is, and try and work with them to alleviate that concern. If ultimately, though, the employee doesn't want to return and doesn't have good reason for not returning, it is open to an employer to treat it as the employee being absent without leave, refusal of a reasonable management instruction, although you would only go down that route of having fully exhausted other options. And also, if the employee doesn't work, then they're not entitled to pay in most circumstances. But if you do have real difficulty with an employee, obviously take advice before doing anything drastic or that could lead to potential liabilities further down the line. Jaspal is now going to just take a quick look at the self-employed income scheme.
Thank you, Michael. As we've already discussed, the government announced the coronavirus job retention scheme on the 20th of March, and at the same time announced that it would suspend the minimum income floor for self-employed persons claiming universal credit, so that self-employed persons were broadly put in a similar position to employees receiving statutory sick pay. The lack of support for self-employed persons attracted some criticism, and the Self-Employed Income Support Scheme was announced on the 26th of March. The self-employed scheme is different to the job retention scheme in two principal ways. Firstly, rather than self-employed persons making a claim through the government gateway, individuals will first be contacted by HMRC if, based on their historic self-assessment tax returns, they are considered by HMRC to be eligible. Only then will they be invited to apply under the scheme. Secondly, unlike the job retention scheme, which allows most employees to be furloughed regardless of salary, the self-employed scheme operates with a cliff edge cutoff where, historically, self-employed persons have had recent annual trading profits of £50,000 or more. To be eligible for the self-employed scheme, the individual must meet the following requirements. They must have traded in the 1920 tax year and still be trading when they apply, or would be so trading except for COVID-19. They must have submitted a self-assessment tax return for the 1819 tax year by an extended deadline of 23rd of April 2020. Their trading profits must have been less than £50,000 than the 1819 tax year, or their average trading profit over the last 3 years must have been less than £50,000 a year. More than half of their income must have come from self-employment during the relevant periods. They must intend to continue trading in the 2021 tax year. And finally, they must have been adversely financially impacted by COVID-19. Eligible individuals, including partners, will receive a taxable grant of 80% of their average monthly trading profits over the last 3 years, up to £2,500 a month. The scheme will run for an initial 3-month period and be extended if required. The grant will be paid as a single lump sum covering March to May inclusive, and HMRC hopes to start to pay the grants at the beginning of June. Regrettably, the scheme does not assist self-employed persons who operate through a company and have historically extracted their profits by way of dividends. Introducing the scheme, the Chancellor also obliquely noted that, and I quote, "It was now much harder to justify the inconsistent contributions between people of different employment statuses." Whilst the Chancellor refused to be drawn further on what this meant, it does suggest that self-employed persons may be required to contribute more by way of national insurance contributions in the future, resuscitating perhaps Philip Hammond's earlier attempt to do exactly this. Finally, self-assessment income tax payments on account, normally due on 31st of July, will be deferred until January 2021 for self-employed persons. And on that, I'll hand back to Michael to consider the future.
Thanks, Jaspal. So the future, and we have, as of yesterday and Sunday, a bit more of an idea of where we're going with the future. And the two key documents is the government yesterday, following the Prime Minister's announcement on Sunday, produced a plan basically as to how it sees the country getting back to some level of normality. It accepts that that's going to be a long way off, and it's really only when we have some medical treatment for coronavirus that will be back to full normality. But it's certainly changing the emphasis of its guidance. The government, certainly in England, has taken away the stay-at-home guidance, although that still exists in the other devolved nations. And the emphasis is very much on where possible, we'll get people back to work where we can make it safe. And certainly that's the emphasis going forward. From an employment law point of view, the situation hasn't really changed radically in the last couple of days. It's always been the case that anyone who can't work from home, doesn't work in a business that's been closed, can go to work. There was some miscommunication and confusing communication in relation to the original lockdown, where some people seem to assume that only essential workers or key workers can go in, but that's never been the case. What the government has done in the last couple of days is make it clear that they are actively encouraging people to go into work if they can't work from home and their workplace hasn't closed. Another key change that's come out of the guidance is this idea that the government are going to encourage people to, if they're working in enclosed spaces with people they don't normally mix with and they can't socially distance, to wear homemade face coverings. That is a new piece of guidance that has come in, but largely the position will remain the same for the time being as to working and what the future looks like. What we do know though is the plan is at some point from the 1st of June, some schools and early learning will return, although we certainly know it's not going to be all schools returning. Some are unlikely to return till at least September by the sounds of it. Non-essential retail will start opening in a phased return, and as for those businesses that have been closed, the government are looking at some point after the 4th of July. This is all very much dependent on the current measures working and the government's 5 tests that they've set out being met. So that's where we're at with the current guidance. The government have also published 8 workplace guidance documents. They relate to specific types of workplace and the environment rather than sector. So they are construction and other outdoor work, factories, plants and warehouses, homes, lab and research facilities, offices and contact centres, restaurants offering takeaway and delivery, shops and branches and vehicles. The guidance is largely the same with slight adjustments to cater for the different types of work environment. Importantly, it's not statutory guidance. The employer still has to follow its usual health and safety and employment law responsibilities. The guidance needs to be adapted by each employer to fit in with its own particular circumstances. And that's also a reflection of the fact that different employers might have different needs, different abilities to comply with the guidance, and also some employers might have to utilise more than one guidance, for example, if they have offices and warehouse facilities. Importantly, from an employment law point of view, a lot of the guidance, I'd say, primarily relates to health and safety issues in some ways, but around employment law, the government are encouraging the employer to consider shift work and to manage workplace groups, so individuals are working with distinct groups and minimising the contact with other people. That's certainly going to lead to a big change in how we work going forward. Employers are going to have to possibly look at changing T's and C's to accommodate shift working, part-time working, for example. In relation to the next few slides, what we're looking at is the changing workplace, the problems that are likely to arise for businesses going forward. such as redundancy, collective redundancy, and changing terms and conditions. Now, before I do move on, we've had a question that relates more to return from furlough, which I think is quite relevant. One of the questions is, what do we do with someone who lives with someone who is shielding? Someone who's shielding are the people who are extremely clinically vulnerable, and they have received a letter from the NHS to stay at home for 12 weeks. In relation to those individuals, so if someone lives with a person who's received that letter and that person should shield, the guidance isn't that the person they live with has to necessarily shield. They obviously should try and do their best to protect the person they live with and shielding, but the specific shielding guidance doesn't apply to the person they live with. Neither does that individual have the same level of protection. So, for example, in terms of the right to SSP. So you are in a difficult position if you do live with somebody who is shielding. And the advice in that situation is, where possible, an employer should, for example, try to consider furlough. If it can't consider furlough, look at other alternatives. Can it give that person some form of paid leave? Can it give that person the right to take some holidays during that period? We'll have that conversation with that individual, because they are in between two stools to a certain extent. If we now move to change in terms and conditions, and one of the questions that was asked is basically, how do we work with employees to change hours or reduce pay to avoid redundancies? That's where change in terms and conditions would come in. It would also apply if, based upon government guidance, a workplace has to change maybe shift structures, duties of employees. The first place to look, always the contract. If you have the right to make the change in the contract, it makes life much easier, and you make that change in accordance with the contract. So, for example, it may say that you must give the employee 1 month's notice of that particular change. However, be careful. First of all, just because the contract says you can make that change doesn't necessarily mean you can. Is that clause something that you have used, are likely to use? Is it going to continue to be enforceable? If in doubt, take advice. Also, contractual provisions are unlikely to permit you to make substantial changes unless they're very specific, unless they have been used in the past. So, for example, reducing an employee's pay will usually require you to engage in some consultation with that employee. If there's no provision in the contract that allows you to make a change, or you don't think that the clause is going to be sufficient for you to make a change, first of all, you seek to agree with the employee. That means engaging in some consultation, try to work with them, maybe give them something in return, such as additional holidays and additional bonus, if you're asking them to do something else and they're not willing to agree voluntarily. What you will find, though, is that many people in the current climate will agree. They'll appreciate if you explain to them the issues and the risk for the business and the fact that you're trying to save the business and maybe their jobs. Many employees are amenable to making changes, even if it means they're out of pocket or they suffer what effectively is a detriment to them. You also need to consider, if there's, for example, a recognised trade union, you will need to discuss and agree any changes with that recognised trade union. If the employee won't agree to the changes and you don't have the right to make them, the two options are: you could seek to unilaterally force through the change. The risk there is the employee could resign and claim constructive dismissal, or they could work under protest. And, for example, if you reduced pay, they could continue to work, do so under protest, and then bring a wage claim in relation to the reduction in pay. The other alternative, and you must take advice in relation to this because it's a big step, is you can terminate their existing contract and re-engage on a new contract. If you do that, you end the old contract, so they can't work under protest and claim their original rate of pay, and then going forward, they will work on the new contract. However, the problems with that are it amounts to a termination, so there's the risk employees may bring unfair dismissal claims. Also, if there's 20 or more individuals you do that to, or you're proposing to do that to, it will trigger the obligation to collectively consult. The next issue, and it's undoubtedly going to happen, there's going to be lots of redundancies. I heard the phrase today that furlough is effectively a waiting room for mass redundancy, and to an extent that unfortunately may be correct. On the screen we've got the definitions of redundancy. Closure of business, closure of a particular workplace, so for example a branch of the business, and the most common form of redundancy is a diminished requirement of the business for employees to do work of a particular kind. Effectively, not always, but headcount reduction. Usually there's 10 people in a particular department. Going forward, you only need 7. That is that third example there. Tribunals don't tend to go into too much detail when investigating the commercial or operational reasons for redundancy. They're looking to see that the employer has sufficient justification, that they don't think it's a sham, that they believe the employer, but ultimately the employer must still be able to show that redundancy was a sufficient reason for dismissal. Other preliminary points to consider: is there a recognised trade union? You should engage with them even if it's not a collective consultation. Do you have any policies or enhanced redundancy pay entitlements? This can be a particular problem if, for example, employees have tupied into the business, particularly if they've come out of maybe large conglomerates or public sector employers. There might be terms and conditions that you're not aware of, but will apply to the employee. And I have come across in the past examples where, for example, an employee has had a document, the employer's not been aware of it, but it actually provided for an enhanced, significantly enhanced redundancy payment that the employer only found out about after dismissal. And importantly, which we're going to come on to in a second, consider the number of redundancies, because there might be an obligation to collectively consult. When making a redundancy, some of our local offices are running webinars over the next month or so, which look at redundancy in more detail. But a tribunal is essentially looking for an employer to have acted fairly in relation to that employee. Redundancies, when they do go wrong, are because an employer hasn't properly consulted, hasn't followed a fair selection process, or hasn't considered suitable alternative employment. Consultation is all about making sure the employee knows what the proposal is and giving them an opportunity to engage and put forward alternative suggestions. The selection process is all about identifying an appropriate pool from which you're going to select employees, if necessary, coming up with a fair selection criteria and then scoring that criteria fairly. When it comes to fairness in relation to the selection, it's for an employer ultimately to decide the process that they use, the criteria they use, the pool for selection. What a tribunal is looking for is that an employer has acted reasonably. Reasonableness for employment law purposes is the range of reasonable responses. Could a reasonable employer have done this in certain circumstances? The answer is yes. Then, if the answer is no, then it's unfair. If any element of dismissal is unfair, then no dismissal is unfair. Voluntary redundancy, it's a way of potentially short-circuiting the need for the full consultation process. It avoids the need for the employer to make difficult decisions. A couple of points to bear in mind. The employer doesn't have to accept a request for voluntary redundancy. Voluntary redundancy is not a resignation. It's volunteering to be dismissed by reason of redundancy. And importantly, most voluntary redundancies are likely to be considered towards the numbers for determining if collective consultation is required or not. So simply choosing people as volunteers will not get you around the need to collectively consult if combined the numbers all satisfy the requirements of collective consultation. One of the questions we've had is how individual consultation fits together with collective consultation. They are both separate things. Collective consultation, which we'll look at in a second, is with an appropriate representative of the affected employees. Individual consultation is with the individual who is at risk of redundancy. You need to conduct both processes. The collective consultation process will start first, and then you individually consult as appropriate during that process. If there's not a need to collectively consult, then obviously you just need to individually consult with the affected employees. Collective consultation, this is something that in 2008-2010 period, lots of employers didn't realise they didn't have to comply with. And I myself was involved in a claim where we acted for 16 employees. The union acted for some more employees, and the employer ultimately ended up paying over £1 million because of their failure to collectively consult. That was in addition to unfair dismissal awards, notice pay awards, redundancy awards. So it's a significant liability if you get it wrong, and I'll come on to the specifics in a little while. Collective redundancy obligation kicks in if there's a proposal to dismiss 20 or more employees at one establishment within a 90-day period, and then there's 2 minimum consultation periods. For 20 to 99 employees, it's 30 days. For 100 or more, it's 45 days. If you happen to have an establishment in Northern Ireland, that 45 days is actually 90 days. A few points to note: redundancy has a wider definition as the one we've just looked at. For collective consultation purposes, it means termination of a contract for a reason that's not related to the employee. So it doesn't include conduct capability dismissals, it doesn't include expiry of fixed term contracts, but it would include, for example, a decision to terminate and re-engage, even though that technically wouldn't be a redundancy. You can start the process, and you can start a redundancy process during furlough. You can dismiss employees during furlough. And as I say, it's separate from individual consultation. Another important point to note is you consult with the appropriate representative. You're not consulting with the individual, and simply consulting with the individual won't be sufficient to comply with your collective consultation obligations. An appropriate representative will be a recognised trade union. If you happen to have a standing body such as a workforce council, then that may be sufficient to act as the appropriate representative if it's got appropriate authority. But for most employers that don't have a recognised trade union, the appropriate representative will be an elected employee representative. It's for the employer to decide how many representatives the group of employees will have, and that will be determined really by the numbers and the categories of worker who are at risk of redundancy. It's for the employer to conduct the election if necessary, and there are statutory rules for that election. And the process of collective consultation won't start until the representatives are in place. So when you're looking at the minimum consultation periods, bear in mind that for many of you, you will have to conduct the elections before you can actually start the process. And the start of the process will typically involve the employer has to provide certain information to an employee representative. That information is summarised there in the first slide. That needs to go to the employer representatives, and at the same time or before, a HR1 form needs to go to the Secretary of State. A failure to provide the HR1 form would amount to a criminal offence. So that's the start of the consultation process. The end is when the first dismissal takes effect. That's when the employee's employment terminates. For that point, it's important to note that if an employee leaves early by reason of redundancy, so that might be a volunteer, or it might be that someone wants to leave early because they've got another job, for example. If they leave early before the end of the minimum consultation period, that might well be a breach of the collective consultation obligations. So usually it's not possible for employees to leave early, but if you do have that situation, certainly take advice before you allow an individual who is otherwise redundant for the purpose of collective consultation to leave early, because you could be putting yourself at risk of a claim for failure to have properly collectively consulted. Collective consultation should be with a view to reaching agreement with the employee rep, so you must enter it with an open mind. And the primary purpose of it is to look at avoiding dismissals, reducing the number of dismissals, and mitigating the consequences of the dismissals. It's also a good idea, if you can, to agree the redundancy process, the selection criteria, etc., with the employee reps. It won't make the dismissals fair, but it certainly helps in avoiding problems later on. It certainly makes it more likely that the process will ultimately be determined to be fair, decided to be fair by a tribunal. Consequences of getting it wrong. I mentioned before, in the case I dealt with a few years back, liability was over £1 million. The consequences of getting it wrong are a protective award of up to 90 days pay per affected employee. And with collective consultation, you are consulting with the representatives of affected employees, not just those employees that are at risk of redundancy, but any other employee who is affected by measures related to the dismissal. So again, bear that in mind when determining which employees should be allowed to elect representatives, if indeed you are in need of having to elect employee representatives. So that's a brief overview of changing terms and conditions and redundancy and collective redundancy. We're now going to hand back to Jasper, who's going to discuss bonuses and share plans and some of the tax issues.
Thank you, Michael. Just a few further points and observations from me. We're obviously in extremely unusual times. Clearly, businesses will be looking at ways to preserve cash in the coming months. One method by which they might do this is by suspending or cancelling discretionary or other bonuses. The Investment Association guidance, for instance, suggests that companies that have suspended or cancelled dividends on account of COVID-19 should reflect this in bonus payments for 2019. This raises some interesting legal and tax issues if the entitlement to a bonus has already crystallised. Alternatively, employers may seek to replace cash salary or bonuses with equity-based rewards. This also needs to be considered from a tax and legal perspective. In some cases, doing so can be tax efficient, particularly if the share or share option scheme is tax advantaged. What should an employer do in relation to any performance conditions in existing incentive or bonus plans? Should it waive or vary these if these are no longer fair on employees? Well, the Investment Association guidance is again opposed on the basis that it would be unfair to shareholders, but private unlisted companies may not feel beholden to the Investment Association guidance. There are also likely to be specific issues for employers that have adopted tax advantage EMI, SIP and SAYE schemes who are seeking to make changes, as the rules of these schemes set out a number of requirements in relation to the employing companies, employees who benefit from the schemes, and the shares the subject of the award. Finally, you've talked about redundancy. What about the tax consequences of redundancy? There are generous rules around taxation of termination payments, which may make accepting a redundancy more attractive for employees at no additional cost to an employer. There are a whole host of tax reliefs and deferrals beyond the coronavirus job retention scheme and the self-employed income support scheme, which have been announced by the government, which we haven't been able to discuss today. As a shameless plug, please do join us for a further talk considering these, as well as the various loan funding schemes this Thursday. I think that takes us on to questions, and I think I'll kick off with a couple of questions that we've had. One of the questions is in relation to the 21-day 3-week period, and is there any significance? I'm happy to address that one, and it's really quite simple. In order to furlough an employee, the employee has to agree to cease work for at least 21 days. So that is the minimum period that an employee can be furloughed for. There was a lot of doubt around this initially, and there was also a lot of doubt around whether employees could be circulated in and out of furlough. But together with the 21-day minimum furlough period, the government has confirmed that employees can be circulated in and out of furlough, and that obviously allows employers some flexibility to ensure that if there are employees who are working for 3 weeks while others are on furlough, they can be rotated to sort of balance things out and make things a bit fairer. So hopefully that answers that question. Another question that we've had is, if we pay our staff the furlough wage and then find the government is unable to reimburse us, where do we stand? Well, this presents an interesting question of public law, which may be keeping us lawyers busy in the coming years. The need to respond quickly has meant that the government response has evolved piecemeal, leaving lawyers and advisors and employers in the unusual position of having to rely largely on ministerial announcements and hastily published and frequently updated online guidance. As far as I can see, neither the direction nor the guidance sets out any specific appeal process, but suffice it to say there are a number of existing legal mechanisms, including judicial review, by which the government could be held to the directions and the guidance. Of course, it is possible that HMRC could seek to deny a claim made under the portal, and based on the guidance probably will do so if the correct information has not been supplied. However, based on our understanding that claims are being settled within 4 to 6 working days, an employer should know sooner rather than later, and hopefully HMRC will be quick to engage with such employers. Stepping back, in practice, it seems to me that more likely than HMRC denying a claim in the first place, and to think in that regard, we would assume that following 20th of April and the portal opening, most employers will time their claims to ensure that, so far as possible, they receive furlough sums before it has made any payments to employees, is that HMRC seek to recover furlough sums paid to employers following an audit by HMRC in the coming years. In that regard, employers are best advised to document their decision-making as thoroughly as is possible and to keep extensive records. One of the things that we've glossed over in this talk is that there are a number of ways in which the various pieces of guidance on the job retention scheme diverge, or in some cases contradict the direction issued on the 15th of April, which is the legal source for the scheme. For example, the position in relation to employees who had already undertaken unpaid leave before the 28th of February. HMRC have said that they will endeavour to read the directions in light of the guidance, but strictly this may be beyond their legal powers. We don't really know how this would pan out in the courts, and one would hope that HMRC would take a common sense approach, other than in cases of egregious abuse by employers. But I think this is another reason why it's important to take advice on the scheme and to consider the risk of relying on the guidance where it is at odds with the direction. So hopefully that answers that question as well. Michael, there were a number of questions on holiday pay and others, which I know you've talked about. I don't know if you want to say anything further about.
Yeah, there's just a couple of points I'll pick up from the questions. In terms of, one of the questions is around those with less than 2 years pay, 2 years service, continuous service. Now, for individual purposes and unfair dismissal purposes, them individuals cannot bring ordinary unfair dismissal claims. By ordinary, I mean an employer needs to show that they've got a potentially fair reason to follow the fair process. Those employees cannot bring those claims. They still can bring automatic unfair dismissal claims. So, for example, if they've been dismissed because they've raised a health and safety concern with their employer, they can also bring discrimination claims. So those individuals have limited individual rights. However, if their employment is to be terminated by reason of redundancy for collective consultation purposes, so for a reason not related to them, then they will fall within the relevant numbers for determining whether collective consultation is required. Employees whose fixed-term contract expires, they are not counted towards those numbers, but certainly any employees who would otherwise be made redundant, whether they've got 2 years or not, count towards the numbers for collective consultation. Another point that I should mention as well in relation to collective consultation and the protective award, if as an organisation you are asking individuals to enter settlement agreements, take advice on the collective consultation point, because settlement agreements cannot settle claims for a protective award or that an appropriate representative or employee might be able to make. Now, they can settle the actual award themselves. So it's important that your advisor properly words the settlement agreement in order to make sure that you are protected from claims if you do decide to go down that route and there are potential breaches of the collective consultation rules. We've had a question on holidays and carryover. You may have heard that the government have permitted employees to carry over up to 20 days leave, which stems from the Working Time Directive under EU law. That can be carried over if they're unable to take that leave because of or for reasons related to coronavirus. There's not a lot of guidance as to what that would actually mean, but if they can carry over that leave, then that leave should then be taken within the next 2 leave years. And our advice to employers would be to take a common sense approach in that in the current climate, employees are obviously going to be limited in what they can do with their annual leave, but also an employer has to manage its holidays effectively. But certainly for the 20 days leave, if the employee can show they couldn't take it or reasonably take it for a reason related to coronavirus, then they will be able to carry that leave over. So I'm not sure if I've got quite a few questions, but we're not, and we have had some come in directly as well. So thanks for your questions. We're not going to be able to get through all of those today, but what we will be doing, and I think we're nearly at our hour, so we'll probably just look to wrap up now. What we will be doing is we'll get all of your questions and we'll provide responses to all of those questions and be contacting you in the next few days with answers to those questions. So if you have raised something today or directly with us before or during the session, we will definitely answer all of those questions. If you have any general queries, do take a look at our coronavirus hub if you haven't done so already, because we have a Q&A on the self-employed scheme, the job retention scheme. We have an employer Q&A, and we're continually updating it in relation to all of the various legal developments around coronavirus. But otherwise, unless you've got anything to say, Jasper, I think we'll conclude the session.
Well, the only point I did see that someone has asked anonymously, is there a maximum time period by which a claim within the job retention scheme may be made? I thought I'd pick this up in the sort of the claim process, but essentially when you put in a claim period, the maximum claim period cannot be more than 14 days after the date that the claim is submitted or the end of the claim period. Currently, the scheme is supposed to and is set to continue until the end of June. So in principle, it is possible to have several claim periods between now and the end of June. But as Michael has said, we don't know what will happen in terms of extending the scheme, whether it will go through to September, whether part-time working will be allowed, or hopefully we'll have further information later today. But I thought I'd just answer that question because it is anonymous, so we might find it more difficult to go back to that person if we don't have their details. But no, I don't have anything further, Michael.
There's just one question. I'll answer it in more detail in writing after the session, but just a quick one on employee reps and the right not to be dismissed. And an employee rep must be an affected employee. So if there's an election, the representative must come from the group that are affected. The representative could well be dismissed as part of that process. They certainly shouldn't be dismissed because they are an employee representative or a trade union representative, but they could certainly be made redundant during that process because an appropriate rep should be part of the affected group of employees, and therefore there's a good chance that they are potentially at risk of redundancy. So that's just a quick point, but I will clarify more detail when we follow up with the written answers. But otherwise, thanks everybody for listening, and I'm sure that I know there are definitely a few of you listening because you have sent in questions, but thanks for that and have a great rest of the day.